The PR essay question from July of 1997 is about as difficult a pure PR question as you will ever see. What's difficult about it is you've got to come up with all of the issues on your own, you've got to organize it carefully, and you have to answer within time constraints. And there are plenty of issues here, making this a rather challenging question to organize and answer well under time constraints. Take a look at the call of the question, and we see a typical PR call. What professional responsibility issues are raised by Ann's conduct? Discuss. This is very straightforward. We have to isolate everything this attorney does, and we have to judge it according to our standards of professional responsibility. So, here, as elsewhere, our real job is to be good reporters about what happened, and good attorneys for interpreting these facts in conjunction with the law. So, what we will do is carefully review the fact pattern, identifying every decision and every action taken by the attorney, and then our presumption will be to organize this answer chronologically around the conduct of the lawyer. As we'll see in this seminar, there's more than one way to organize many of these questions, but when we get a call like this, asking us to interpret the conduct of an attorney, the best way to do it is organize chronologically. So, let's go to the top of the question and see what happened here. In paragraph 1, we meet attorney Ann. She is licensed here in California, and most of her practice involves representing poor tenants. Paragraph 2, we meet Frank. Frank is a friend of Ann who tells her about an apartment complex that appears to be run down and have needy tenants. Ann visits the building. She's shocked by the dilapidated and unsafe conditions. So far, no problem. This attorney hasn't done anything other than have a look at an apartment complex, and taking a look doesn't really rise to the level of practicing law. But what she does next does. Next, Ann sent a letter to each of the tenants in the building, and we are given its content. We are told that she writes, "It has come to my attention that there may be illegal and unsafe conditions at your apartment building." Well, that's true. She goes on to write, "I am an attorney experienced in this type of case." Also true. "And I am willing to represent you in a lawsuit against your landlord regarding these conditions." Call today. So far, almost certainly, so good. It doesn't look as if Ann has crossed any ethical boundaries. Next, we meet Tom, a tenant, who calls Ann in response to the letter and tells her that he wants help suing landlord. He says that another tenant, named Barbara, who is 82 and only speaks Spanish, also wanted to hire Ann. All right, well, we pause right here and we see a potential conflict of interest. When an attorney represents two claimants, we've got to make sure that there is no dispute between those two claimants, either a factual dispute or a potential legal dispute involving differing goals. We move on and we see Ann meeting with Tom and Barbara. Ann doesn't speak Spanish very well, so Tom acts as a translator. Another potential problem. It became clear, as the fact pattern says, that Tom's interest was in obtaining a money judgment, and that Barbara's interest was in obtaining equitable relief requiring the landlord to make repairs. So we find out about an actual conflict of interest between two clients. So if Ann represents both of them, there's a potential problem. Next, Ann, Tom, and Barbara sign a contingent fee agreement for Ann to represent Tom and Barbara in a lawsuit against the landlord. Under the agreement, Ann gets 40% of any recovery in the case. There is a separate agreement between Ann and Frank that she would pay Frank 10% of any fees she recovers in return for his having told her about the apartment complex. Well, we know that attorneys are not allowed to split fees with non-attorneys. And actually, when an attorney splits a fee with counsel, there is a requirement of notice. So, certainly, we've got a potential significant ethical issue here. In the following paragraph, Ann sues landlord. The suit has a sound legal basis, and she handled it in a professionally competent manner. So, her actual attorney work on the case at bar is up to professional standards. It's just everything else she does that's going to give her problems. And it gets worse. In the following paragraph, we see Anne and Tom developing a relationship. And the client, Tom, asks Anne to date him, and he gives her a free airline ticket to go with him to Hawaii, which she accepts. So here we've got a romantic involvement between attorney and client. On its face, this is not a per se violation. But as we see, it is an obvious conflict of interest that compromises the work that Anne does on behalf of Barbara, the other tenant. Next, we find out about a written settlement offer from the landlord to pay money damages only, which Anne conveys to Tom. Tom does not consult Barbara and tells Anne that Barbara accepts the offer. Anne settles the case, and then we get the call of the question again. So, as I said up front, this is not a terribly easy PR problem. The reason is we've got a lot of facts and comparatively little structure given to us. So, first, we have to impose a logical structure on the analysis, and then we have to actually do the analysis in the Blue Book and arrive at conclusions that make sense. So, take a look at my outline of issues, and you'll see here again, I do not do a great deal of internal organization beyond the first 2 or 3 issues. All the rest are a mere laundry list that allow me to focus my analysis along the lines that I outlined earlier. We are going to look at everything this lawyer does, and we are going to examine it with regard to PR issues. So, notice the big picture of my organization. I focus on the solicitation letter, the joint representation of Tom and Marie, the fee agreement, the fee splitting agreement, the lawsuit, the relationship, and the settlement agreement. Those are the big topics. That's what this attorney did. You'll notice I don't have a separate section on her driving by and looking at the property. I don't think that's really part of her practicing law. I don't see it giving rise to any issues. If you threw in a line or two about it, I don't think there's a problem. It doesn't cost you much time. Also, you'll notice that this subject, as in others, I avoid boilerplate. Now let's take a look at the answer and you'll see what I mean. You'll notice that up front, I don't write a little mini canned essay about what PR is. I think it's much better to display our understanding of professional responsibility law in connection with analyzing the facts. So, here, as elsewhere, I do not begin my answer with a recitation of law. Instead, I begin this answer, as I begin almost every answer, by leading with the facts. I focus on who Anne is and what she did. She sent a letter to each tenant in a badly run-down apartment building, and in her letter, she truthfully states that she's experienced, and she offers to represent the tenants. I indicate that attorneys have a First Amendment right to free speech, and that includes the right to advertise, subject to reasonable regulation by the state bar. So, I indicate some law in the second paragraph about the prohibitions against false or misleading advertising. I indicate that tenants are especially vulnerable to manipulation. But I indicate that the letter appears to be correct. Nothing about it is false or misleading, and also, importantly, she does not try to guarantee a result, which is a big red line that we are not supposed to cross in our advertising. Notice, however, that the letter makes no reference to price. We're concerned about this, but in the overall context of the letter and the fact pattern, I don't think that it rises to a level of a breach of professional ethics. She doesn't appear to be seeking a deposit, and it doesn't look as if she is being manipulative beyond the actual fact of sending the letter. I focus on how this is a targeted direct mail advertising campaign, and here the problem is we are not told by the facts that the letter is labeled as a solicitation. We don't know that the envelope and the actual letter have any indication of advertising content. And since it looks like she failed to properly label per direct mail solicitation, I find that the letter may cause her to be subject to discipline. Next, we move on to what I consider to be a more complicated and a more common issue, and that is we haven't had a lot of attorney advertising or solicitation questions. That's one reason why this question is worth studying in this seminar. But the joint representation issues are more complicated, and they're also somewhat more common. Notice, up front, I lead with the facts indicating that Tom has responded to the letter by Anne. And I indicate that Anne has duties of loyalty and competence, and then I focus on the conflict of interest. That's one of the central problems in this fact pattern. The first time this lawyer met with these two clients, it was apparent that there was a conflict of interest between the clients. Tom wanted money, and Barbara wanted equitable relief, and the attorney ignored this possible conflict of interest, and her subsequent representation favored her representation of Tom over her representation of Barbara. And this is a clear violation of her duty of loyalty and her duty to avoid conflicts of interest. Next, I consider the issue of waiver, and I indicate that a reasonable lawyer could have endeavored to represent both of these clients despite their apparent conflict of interest, but it would have been necessary to explain this conflict of interest and get a written waiver from the clients about it. She failed to do that. The subsequent events prove just how wrong it was for her to represent these two clients. So I indicate that Anne's failure to obtain a waiver and to talk about these conflicts of interest will subject her to discipline. Next, I have a separate section on the translation services provided by Tom. Here, again, another conflict of interest is presented. Since Anne doesn't speak Spanish very well, Tom's acting as translator affords another opportunity for this conflict of interest to play out in a way that compromises Barbara's interests. Also, we see that Tom didn't even communicate the settlement offer to Barbara, and yet represented to Anne that Barbara had accepted it. This is another problem which I discuss subsequent to the second section. So let's move on and consider the fee agreement. Here again, there aren't a whole lot of issues, but there are a couple that are worth discussing. First, I focus on the contingent fee aspect. The amount of the contingent fee is not per se unreasonable. And remember, fees always are judged ultimately on a standard of reasonableness. But the problem with this fee agreement is that there does not appear to be any recitation about costs. Here, the clients have a right to know whether or not costs will be taken off the top before the percentage split is to be made. And if you look at that paragraph of my analysis, I think you may find a nugget or two of law that you may not have known before, particularly if you are not a PR expert at the time that you are entering into this seminar. Next, we consider the fee splitting agreement between Anne and Frank. All we know about Frank is that he is a friend of Anne's. If he is an attorney, then it would be all right for there to be a fee splitting agreement so long as the clients consent to it. Since the facts are silent as to Frank's career choices, I think it's fair to assume he is not an attorney. But if you take a look at my analysis, I indicate that the results would be different, potentially, depending on what Frank does for a living. But even if Frank is an attorney, the apparent failure of Anne to get her client's consent could subject her to discipline. Next, I focus briefly on Anne's lawsuit against the landlord. We are told that her conduct of the case on its face is up to legal standards. So you'll see I don't dwell on the case much, but I do spend one paragraph explaining what we know about Anne's actual handling of the case, and I conclude, predictably, that viewed narrowly, the conduct of the case does not run afoul of ethical standards. In the following section, I focus on the relationship between Anne, the lawyer, and Tom, the client. Both the ABA rules and the California Rules of Professional Conduct urge attorneys to avoid becoming romantically involved with their clients. But these strong bits of advice do not rise to the level of a per se violation of legal ethics. Here you will see that the gift from Tom to Anne is not by itself a violation of professional ethics. It's okay for lawyers to fall in love or to become romantically involved with their clients, and it is not a per se ethical violation for an attorney to accept a gift, even an expensive gift, from a client. But the problem arises when the attorney-client relationship in romance affects other attorney-client relationships. And as we see, it looks as if Tom's interests in this litigation have been put ahead of those of Barbara, and that certainly is a violation that can subject Anne to discipline. Finally, we look to the settlement agreement, and that gives us our last couple of PR issues. We know that an attorney has a duty to communicate all settlement offers to the clients. Anne failed to personally conduct an interview with Barbara, at which time she would communicate this information. Instead, she relies on Tom to do so without Anne being present. And it is clear that this is a violation of Anne's ethical duties to actually represent Barbara. Now, if Barbara had heard about this settlement offer and rejected it, she should have either secured Tom's consent to continue the lawsuit, or Anne should have withdrawn from the case and new counsel should have taken over, new counsel that could represent each of these clients zealously. The bottom line here is it was wrong for Anne to have concluded this settlement without personally consulting with Barbara, and her failure to do so is going to subject her to discipline. And that wraps up an analysis of this rather difficult PR question. Notice that the call of the question asks about the attorney's conduct. And so, a good answer to this fact pattern is framed around the conduct. We focus on the facts, we analyze these facts in line with the ethical standards in California and nationally, and we reach specific conclusions that judge the attorney based on our application of the law to the facts.